Okay, today I want to talk a little bit about transferring property into an LLC. So let's say you've either formed a Series LLC or a regular LLC, and now you want to use that company to hold property, or you want to hold a property and manage it for rental, you want to hold it temporarily, develop it, sell it, whatever it is. The process is going to be pretty much the same straightforward process for each of these situations. Transferring it into a series of a Series LLC, you're going to make sure that you're transferring it into that particular series, which means looking at your Series LLC, your naming conventions, figuring out how you're going to form that series, doing your designation of series with yourself or your attorney, whoever's going to do that for you, making sure that it's formed correctly. Now there's some new legislation about designation of series and what they need to be named, and if those names then need to be registered as DBAs under your entity with the Texas Secretary of State. But moving property to an LLC, the one thing I always caution folks on is if you're moving that property into the LLC and there's debt on the property, there's a mortgage, there's a seller financing document, any kind of promissory notes, debt, mortgages, etc. on the property, you need to notify your lender, whoever holds that mortgage note. 99 times out of 100, this is not going to be a huge deal. If you're transferring it to a single member LLC or just you and your family, whoever is members or managers of that Series LLC or regular LLC, like I said, they're not really going to care because you're still going to be liable on the mortgage. They're not going to let you transfer the mortgage to the LLC, but they might let the holder of the property be transferred into the LLC just for holding the property. You're not going to get out of the mortgage by transferring it to the LLC, but we always want to make sure that we notify them. And why? Because if you look at any of your promissory note or mortgage documents, there's always going to be, in a well-drafted one, there's always going to be a clause that says due on sale. So a due on sale clause means if this property transfers hands, the bank or the mortgage lender, whoever holds that mortgage note, is going to assume that you sold it and you've got money for that property. And they're going to say, okay, well, now you owe us everything that's due under this mortgage agreement, this promissory note, whatever it is. So if you are unsure about this property or how that's going to work, always get in touch with your agent, your mortgage holder, whoever it is, the banker, the seller, whoever has that mortgage note on your property. You need to get in touch with them. Tell them, here's what I'm doing, full disclosure. Here's the operating agreement, shows I'm the only member of this LLC. I'm just moving it here for liability purposes. Not selling the property to anybody but my own self in this LLC, and we're still remaining liable on the note itself. They may have you sign some personal guarantees, that kind of thing, but like I said, we just want to make sure that they know about it. 99 times out of 100, they're not going to object. So we're going to draft the deed. We'll draft the deed that says we're going to transfer the property. Transferor is yourself. Transferee is the Series LLC, the Series, or the regular LLC. We're going to record that property deed with the recorder's office in the appropriate county. And that's kind of it. We want to make sure that those corporate records are up to date when you are transferring it into that LLC. My clients know I harp on this stuff all the time, but you have to absolutely make sure that you are maintaining corporate records. So you can't just on a whim decide now that the LLC has property, right? So we want to make sure we have a corporate resolution that goes through that. We want to make sure we have a meeting of the members that took place, even if it's just yourself. It sounds weird, it sounds odd. You're going to be sitting there writing things to yourself and signing things to yourself as a member and a manager, whatever it is. But we want to make sure those corporate records say. So we've got to have the deed of the property, the recorded deed. We want to keep that with our LLC books. We want to keep an LLC receipt of property, just a receipt that says we got this property from this member. And if you're going to use that as a capital contribution, you want to record that in your assets. And have your accountant make sure that that's recorded in the capital accounting, if that's going to count towards it, however your LLC is set up. So that's kind of a broad overview. We went some broad strokes on it, but I think it should give you some answers on, can I transfer this property, or should I transfer this property into my LLC, and what does that look like? It's a fairly straightforward process. There's not a whole lot that goes on that's weird or different than any other regular transaction. It can be accomplished fairly easily, fairly quickly with an attorney, and a lot of folks try to do it themselves. you can do that. I'm obviously going to recommend that you hire an attorney, especially with recording of documents and corporate governance issues with your LLCs. So hope that answers some questions and gave you a little bit of insight on how we transfer property into an LLC.